and we'll share a link to the recording later today. So what we'll be doing is we'll go through economic dismissals in general. Then Mick will take it over and guide you through how you need to motivate a dismissal for economic reasons. I will then pick up on the topic selection of employees. And then Mick will address the topic of relocation, repositioning of employees. We have a couple of other topics, and then we'll have some time to address your questions, and we'll finalize the webinar. I think we'll take about 1.5 hours max, max 2 hours, I would say. Feel free to leave the webinar if you have other things you need to attend to. Of course, we'll share the recording. All right, let's get started. In general, so what does the Dutch law say about dismissals for economic reasons? Well, since the introduction of the WWZ, the WWZ, in 2015, it has been made possible only to direct a economic dismissal through the so-called UWV proceedings. Previously, it was also possible to enforce a dismissal through court. But you had a strange outcome that if you would do the dismissal via the court, the outcome could be that the court would award this employee the so-called neutral sub-district court formula, which was at the time about, well, average 3 times the transitional compensation we now have. Whereas if you do the same proceedings, so the same dismissal for economic reasons through the UWV, you didn't have to pay anything as an employer. So that was considered to be a weird, strange outcome. Ever since 2015, it is you can only direct a dismissal for economic reasons either through a settlement or through proceedings via the UWV. The law doesn't say much about what you need to do to motivate. The Dutch Civil Code says, well, you need to have job losses due to the abandonment of the company, or when jobs are necessarily lost due to economic circumstances and the measures are necessary for efficient business operations. So that's a very generic. Those are very generic conditions. Hence, what you see is that the UWV applies its own regulations. And in those regulations that are about 100 pages, a number of rules are included on how you need to motivate, substantiate a dismissal, how you need to select employees, what you need to do in terms of repositioning. So those regulations, they are updated regularly. Plus, you have a lot of case law, and that case law is not so much about the UWV proceedings, as well as court proceedings and appeal court proceedings, because if you've, after a decision of the UWV is taken, it is possible to appeal to that decision with the sub-district court and afterwards with the appeal court. So what does the procedure look like? So in principle, the procedure is completely in writing. In simple cases, one written round takes place. And so you would have, as an employer, you would submit your request for dismissal. The employee would be able to provide his defense letter, and you get a decision afterwards. It takes about, 1 month, 1 to 2 months. In case you get a permission, so the UWV decides only about whether or not, as an employer, you can terminate the employment agreement. What you can do is deduct the time it took to go through the proceedings from the notice period. You retain at least 1 month. Then you submit a notice letter to the employee saying, well, we have received the permission by the UWV to give notice. Please find, here is your notice letter. This is your last day of employment. you will receive a final settlement, and we will also pay out the transitional compensation. The UWV does not rule on the final settlement, so what we call in the Netherlands the eindafrekening, and it doesn't rule on the transitional compensation or how you calculate this. So that's the only thing the UWV does is to test, well, do you have a ground for dismissal, and can you terminate the employment agreement? That's it. So indeed, apart from the fact that you can terminate, you have some obligations as an employer. You need to provide the employee with a final settlement. So any outstanding holiday allowance should be paid, outstanding holidays, the transition payment. But if you don't pay it as an employer, it's up to the employee to file proceedings. If he's not, also if the employee does not agree with the calculations made, he or she is the one to submit proceedings. If a social plan has been agreed with the unions or the Works Council, of course this has to be implemented or considered as well if you calculate the final settlement. And usually there is a sober arrangement in a social plan if the employee has not agreed to a settlement agreement, and for that reason you had to start the proceedings with the UWV. On a general view on the role of the Works Council, I know that not all of you have a Works Council, but knowing that you might have one in the future, know that the Works Council has an advisory right to strategic decisions of an entrepreneur of a company, such as a major reduction or change in the organization of the company. And advice must be requested at a time when the advice still has a significant influence on the intended decision. So in general, going through such an advisory process correctly will take a lot of time, because the Works Council would have a lot of questions, might say, well, is there no alternative to this reorganization? But the subsequent discussion with the employees, so after you've dealt with the Works Council, the subsequent discussion with the employees on termination of their employment, it will run much more smoothly. Of course, if the Works Council has already given positive advice. If negative advice has been given, or if the advice has been given under certain conditions, so a positive advice assuming that the employer implements a decision in a certain manner, and the company doesn't want to go along with the conditions set by the Works Council, then as a company you have to wait a month before implementing the decision. So you have the advisory process. It ends with the advice of the Works Council in case it's negative, or in case you don't want to meet the conditions of the Works Council. Have the 1 month waiting period, and during that period, the Works Council can submit a petition with the Enterprise Chamber in Amsterdam, which is a part of the appeal court, department of the appeal court, and the Works Council can then ensure or apply, ask the Enterprise Chamber that the decision will not be implemented. So we can organize a separate webinar about the advisory process with the Works Council, but for this moment, we suffice by saying that it's important to include the Works Council in the situation when you are about to reorganize. And if the Works Council is already informed broadly on for instance, the financial situation of the company, a reorganization will not come as a complete surprise, and the time it will take to go through the proceedings, the advisory process, it will be much shorter. So that is the important reason to take the Works Council seriously, to take it serious, and to include them in your decision-making process. If no Works Council has been set up, nor has been asked for to set up by employees, you don't have to set up a Works Council when you have to take a decision that requires advice. If you've already been asked to set up a Works Council, you run the risk of the UWV rejecting the dismissal application as premature, because then the idea would be, well, say you take the viewpoint of an employee, and the employee has requested to start up or to set up a works council in the past, you didn't do it, then a couple of years later you try to fire this employee, he would argue, well, in 2016 I've asked my company to set up a works council, they didn't do it, now they want to implement a decision that is subject to the advisory right. I think this is premature, they should set up the works council before doing so. The UWV will go ahead with the argument of the employee. Also, the UWV will reject the application if no advice has been requested from a works council that is established, even though it should have been. So if you have a works council, if you don't ask advice to the works council where you should have done it, the application for termination will be rejected. So what if no works council has been set up because the number criterion is not met? So you probably know that you should have at least 50, not employees, but people working in the company. And then there's an obligation to establish this works council. What if this 50 is not met? Is there no room at all for employee participation? Well, there is. If you, as an employer, want to make a decision resulting in a job loss change of more than 25%, an employee meeting must be asked for advice. So this employee meeting can also be a so-called personeelsvertegenwoordiging, a establishment or meeting of employees that has been established before. That meeting has the right of advice. So the personnel, the employee meeting is not entitled to appeal to the decision. So it's really a formal process where you would ask them for advice, and then basically you will motivate why you go ahead with your advice or why not. But then after you've done that, they cannot do anything about your decision, right? So it's just something you have to take it serious. But then again, if you don't agree with what the employees say, yeah, that's it. Then they cannot appeal. I see a question popping up in the chat. When you say 50 employees, does it mean paid and unpaid staff? Could you please explain more on this criteria? We have 25 paid staff, but 100 volunteers. Thanks. Volunteers don't add to the criteria, to the criterion. But for instance, temporary workers, contractors do. So werkzame personen. Yes. Yeah. Let's see. Roles Works Council. I think we've covered that part. Especially for smaller companies, know that. So if you have a job loss or job change of more than 25%, do know that you have to have put together this employee meeting, because otherwise your application for dismissal can be rejected by the UWV. If those freelancers are abroad, I don't think that strictly matters, because they would all, I'm referring to a question of the Tripreneur team. Don't think that will matter, as long as they are working in the same company. Let's discuss this specific situation and whether you meet the criteria after the webinar. I think we can cover that in 5 minutes. Let's go ahead with the next topic. The presentation works long. The role of the unions. In principle, the role of a union in a reorganization is to conclude a social plan. Although more and more works councils regularly conclude a social plan, the classic division is that the works council focuses on the reorganization decision. So, for example, are there no alternatives imaginable for the proposed reorganization decision? And the union focuses on the personal consequences of the decision. So, severance payments, placements, etc. If no unions are involved in a company, it may be that they are made aware of the reorganization as a result of the notification of collective redundancies. So 20 redundancies in a period of 3 months, and thus get a foot in the floor. If such a report is not made, the employee can nullify the dismissal or the settlement agreement. So also, if you're planning to have a reorganization, then you should know that you have to make a notification for collective redundancies if there are 20 dismissals made in a period of 3 months, and that includes dismissals for personal reasons, and it also includes settlements you have made with people. And this notification, it is relevant for the unions to basically contact you and try to see if you can enter into a social plan. But again, if you don't make this notification, the consequence can be serious, because the employee can eventually nullify a dismissal for that reason, for not notifying the, not making the notification of collective redundancies. Appeal options. Well, there is the option after you've first received the permission of the UWV to dismiss an employee. You would dismiss the employee with a notification letter. What the employee could do is to say, okay, I don't agree with the dismissal. I think you have not substantiated it enough. I think there are repositioning possibilities for myself. And the employee can go to court and say, well, I want to be employed again. Or the employee can also say, I think the substantiation lacks. I don't want to be employed again, but I want to have severance instead. More severance than the transitional compensation. That's what those are the main options. The other option, of course, from the employer side is to, if you have not received permission to terminate the employment agreement, you can submit a similar application with the court, and the court will look, well, taking into account the same regulation, it will look again to at the situation and reassess whether you have a ground for termination. That's the topic of economic dismissals in general. So formally, you now know how the procedure works with a petition that you would submit with the UWV. It doesn't always work like that, because of course you'd like to settle with employees. You don't want to you don't necessarily have to go through these proceedings if you like to settle with employees. And often, I think in 90% of all cases, it is possible to enter into a settlement agreement. And that works as follows. So the UWV proceedings are split up in three written forms, the A, B, and C form. And what you would do is you would submit only the A form for a specific employee and say, well, I want to fire this employee, but I want to try to negotiate a settlement agreement with him as well. You would submit that form. The UWV would say, okay, you get a delay, or you would have a couple of weeks time to negotiate a settlement agreement. And if you haven't, then you'd have to submit the other forms that basically set forth why you want to terminate the employee. That A form, submitting that form is really relevant, because if you would have a discussion a day later or afterwards with the employee on termination, he cannot say, or he can't submit calling sick. But the UWV takes the view that if you have called in sick after this A form has been received, at least a day later, then it doesn't count for the dismissal. So there's there is a notice ban, so an opzegverbod for sick employees, but that doesn't apply if you've submitted the A form and the day later the employee calls in sick. So what you can commonly see is on day one, employers submit the A form, On day 2, they have a discussion with the employee and share the situation, share a settlement agreement. So the proceedings with the UWV are delayed for a couple of weeks. You have some time to negotiate. You enter into a settlement agreement, and then after the 2 weeks revocation period has lapsed, you would terminate the proceedings with the UWV. So that's the way it commonly works in the Netherlands. And then in such a proceeding or such a settlement negotiations, what you commonly do is to offer the employee an incentive in respect of the way the UWV proceedings would end up. So if for instance it's likely that the UWV would decide that that you can terminate the employment agreement, and the termination date would be the 1st of July. You would have to pay 10,000 euros of transition compensation. What is the employee would know, well, okay, that is the likely outcome of the situation. Why would I sign a settlement agreement that entitles me to exactly that amount? There's no reason, because they can just await the outcome of the UWV proceedings. So it's logical and advisable to offer the employee an incentive, for instance, an extra monthly salary on top of that, so that he knows, well, I'm better off by signing a settlement agreement. I will now pass the mic to my colleague Mick and move on 1.5 meters to the other direction. Thank you.
Good morning, everyone. Thanks for joining us for this webinar for business and the dismissal for business economical reasons. I will have a look with you guys on how to motivate the dismissal at the UWV. First, we will have a look at the law. What is a reasonable ground for dismissal in case of a business economical decision to make redundancies? A reasonable ground for dismissal is if redundancies are a result of termination of the activities of the company, or viewed over a future period of at least 26 weeks. Necessarily, redundancies as a result of taking economical measures due to economic circumstances. So there are a couple of aspects in the law we will focus on. For instance, what is the 26-week period, and what are specific economic circumstances that can result in a business economic decision to have redundancies within the company. So you can have redundancies if the termination of the activities of the company, or if redundancies are necessary viewed over a future period of at least 26 months. So what are the grounds, the business economical grounds that may lead to redundancies? Are there any examples? Yes, there are a couple of examples given by the UWV, and it's limited to these circumstances which might which you might substantiate the business economic reasons. There's a list of it. It's a bad or deteriorating financial situation, reduced work, organizational or technological changes, company relocation, termination of the activities of the company, and expire of wage cost subsidy. And we will focus on a couple of those business economic grounds in this webinar. What discretionary power does a company have? By answering the previous question, we have seen that there are different economic circumstances to substantiate the loss of jobs. The starting point for all business economic circumstances is that the employer must be able to demonstrate that the circumstances make redundancies necessary. The employer has, however, a discretionary authority to organize the company in such a way that the future of the company is also guaranteed in the long term. What does this mean? It means that the UWV in a procedure is not going to sit on the chair of the employer to assess whether the choice of the loss of jobs is the right or correct choice considering the circumstances. The UWV exercises restraint and there's a marginal judgment applies for the UWV. So you have quite a discretionary authority as an employer to decide how to run the company. And if you can demonstrate that it is necessary based on business economic grounds to have redundancies, then the UWV accepts that you just demonstrate and substantiate it, and is not going to test if it's the best option possible, but it will test if it's a reasonable outcome. So what information do I need to provide as a company? The foregoing discretionary authority does not alter the fact that the employer must be able to substantiate the business economic conditions. A bad or deteriorating financial situation will have to be substantiated, for example, by providing key financial data about the past and the forecasts for the future of the company. Under certain circumstances, the financial situation of the parent company is also important, and then this information of the parent company, the key financial data of the parent company, will also have to be submitted at the application. The employer will also have to substantiate the application for redundancies on the basis of documents in other possible economic circumstances. So the limited number of business economical reasons we discussed before. The quantity and quality of the documents to be submitted depends highly on the approach for the dismissal application. In the event, for instance, for the bad or deteriorating financial situation, a considerable amount of financial documentation needs to be provided. So all key financial data, so also the annual accounts of the last 3 years and the forecast for the next years needs to be submitted. While in a reorganization based on that redundancies are based on organizational or technical law changes, the employer will have to submit considerably fewer documents. In this business economic circumstance, it's particularly important that the reason for a decision can be well substantiated. So the how and why. So why is it necessary to have redundancies, and how are those redundancies will be affected within the company? But then you don't need to submit all the financial documentation. It's mainly important to substantiate and to submit an org chart of before and after the reorganization to show the UWV why the redundancies are necessary and how they will be implemented within the company. So that's the information. The information you need to provide highly depends on the business economic reason given for the dismissals. Is it allowed to outsource work? Outsourcing of activities will not be considered as a reasonable ground for termination insofar as the employer outsources the activities only to have employees with an indefinite contract replaced by employees who do not work on the basis of an indefinite contract or perform the activities against a lower compensation. Outsourcing to a self-employed person, and zelfstandige in Dutch law, can provide a reasonable ground for dismissal insofar it's a real self-employed person. So it must be a really self-employed person and not someone who's actually an employee based on the assessment of an employee. So if it's outsourced to, for instance, a company or a self-employed person who performs activities for other companies as well, it might be that you a reasonable ground for termination if you outsource the work to a self-employed person. An employer will always have to explain the UWV the reasons to outsource the activities and demonstrate that outsourcing of activity serves efficient business operations and is not just motivated by replacing employees with a permanent contract. So it might be possible to outsource work as long as it's done to a self-employed person, and you can demonstrate as a company that it's for business economical reasons efficient to outsource the activities instead of having it performed by an employee with an indefinite contract. So we'll now see two redundancies. And we will focus on one of the aspects of the law, namely the 26-week period. The employer will have to substantiate that based on the 26-week period, redundancies are necessary. For every job that will be lost, for every redundancy, this must be made plausible by the employer. And the 26-week period, when does it start? Now, it starts from the date that the UWV will decide on the application. So when the decision is made within the organization about having redundancies, a time frame will have to be estimated when the UWV will decide on the application, and then it must be substantiated over a period of 26 weeks onwards. It's necessary to have those redundancies. So it's important that it's not on a short term, that there's not sufficient work anymore for that particular job or that particular function. So it's you have to need to have a look on the further future instead of the short-term future. So who's the employer? It's important to consider who the employer is where redundancies will be affected. In this respect, the employer is a strict legal concept, and being the company with whom the employee has its employment contract. So the formal employer is regarded as employer who will apply at the UWV for the dismissals. For assessment of the dismissal application, the UWV assumes that the company, the business coincides with the formal employer. If the employer, for instance, has several business units, locations, or branches, these are not, under normal circumstances, not considered to be an independent business unit in this respect. So still the employer, the formal employer, will have to apply at the UWV for the dismissals. It might be that there are different so-called business locations, in Dutch bedrijfsvestigingen, in which the principles of reflection, which Martijn will refer to later on, we'll get into later on, but those are bedrijfsvestiging, business locations, are not considered to be a specific business units which applies by themselves for the at the UWV for redundancies. Now, however, the Supreme Court, in a decision of 1.5 years ago, has impacted on this premises. It might be that a business unit is considered to be an independent business unit within a company that has can apply for itself for dismissals based on business economical grounds at the UWV. But then the business unit in total must be seen as an own employer, which is not, it's relatively never the case. Only in big companies, it might be that the specific business unit who's not the employer, so not the formal employer, might be seen as an independent business unit who can, for which the assessment will have to be made if it's necessary to have redundancies at that business unit instead of within the full company of the employer. So the employer still applies at the UWV, makes the application, but the business economical reasons for the application for the redundancies are then considered to be within that specific business unit. But that's only for big business units within big companies, and I assume that we don't have that here in our webinar. What happens if the employer is part of a group? If there are redundancies within an employer whose company is part of a group or which maintains more than one company, the need for redundancies is assessed on the basis of the circumstances applicable to the company, to the employer, where the redundancies will be affected. We've seen that practice question as well. This is an important provision for employers who maintain multiple companies or form part of a group. The starting point, namely, is that the company where the jobs will be lost, where the redundancies will be affected, will have to be assessed on the basis of the business economic reasons that apply to that company. If the company is part of a group and the group as a whole makes a profit, this can still result in jobs or in redundancies in that specific company if the need for redundancies can be made plausible for that company, for that employer. The importance of being part of a group in this case is reflected in the existence of suitable positions within the group. And we will get to that when we'll have it on replacement, reassignment of employees. So if the group is doing well, but a specific company is underperforming, it's still possible to have redundancies within that company which is underperforming. What is a group? Now, a group is an economic unit in which entities and companies called group companies are linked organizationally. It's an economic unit of organizational related parties with central leadership. This comes direct from the law about this subject. It is therefore important to remember that the business economic conditions of the company where the redundancies will be affected are normally decisive. However, if a group is performing badly or the deteriorating financial situation within the group, it might be the case that the specific company is still performing well, up to standard. Nevertheless, it's possible to also have redundancies at that specific company then. The employer, the specific employer, who submits the application for dismissal, will then have to demonstrate upon the submission of the assignment from the parent company, so that it needs to substantiate that, for instance, the parent company decided that at all companies there will have to be redundancies, and in that situation also the financial situation of the group company, the parent company, will have to be submitted at the UWV. So that's the case in which the group itself is not doing well. There's one or there are several companies who are performing up to standard, but also by decision of the group parent company, there will have to be redundancies within those companies who are performing up to standard. Then also the financial situation of the parent company will have to be submitted to substantiate the redundancies at the company, the specific companies. So that's why it's important to assess if the company forms part of the group. Now, is part-time dismissal allowed? The basic concept of the UWV is that an employment contract is indivisible, so it's one contract. This principle might in the near future be affected by a recent judgment of the European Court of Justice That's a couple of months ago, but for now it's still the guiding principle of the UWV that an employment contract is indivisible. So the UWV only grants permission to terminate entire position and the entire employment contract. An employer must therefore be able to demonstrate that part-time dismissal is necessary because it's not possible to terminate one full position. An example given by the UWV is a small installment company which needs 2 installers to perform the job and sees turnover fall by 50%. 2 installers are required to perform the work, so it's impossible to terminate one full position because then the work cannot be performed at all anymore. An employer can solve this according to the UWV by requesting permission to terminate the contract of both employees, so the full contract of both employees, whilst at the same time offering both employees a contract for the remaining work at the company. So for instance, a 50%, a new contract for 50% of the original contract hours for both installers in this specific example. The idea behind this concept, of course, of the UWV is that it's not necessary to apply for dismissal based on business economical reasons, because parties will be able to settle this between them because they know that it is possible to ask for permission to terminate the full contract as long as the employer grants the employees the possibility to stay at the company, but then for the work which remains after the loss of turnover. There are some, and for dismissal of payroll employees, there are some, the legal position of payroll employees has been improved recently, or 3 years ago. So it's important to assess if you have payroll employees at the company and to see what their position is, and of course also what the contract is with the payroll employer, because the position of payroll employees is strengthened recently. I thought I saw a question popping up in the chat. Would another allowed alternative to this part-time dismissal be, for instance, 4 staff agreed to 25% pay and work hours cut rather than dismissing anyone? Yes, of course, that would also be a solution, so that but then this solution is then organized well within the company itself, so without involvement of the UWV. For if you will apply for the dismissal at the UWV, then this might not be the solution, because you will need to be able to demonstrate that you still need those 4 staff to perform the work. So if those four staff people are doing the same work, for instance, then the UWV requires that you will terminate 1 position. Only if you can demonstrate that you need all 4 of them, then it's possible to have the part-time dismissal. So this solution, as suggested in the chat, is possible as an outcome of an internal agreement with all 4 of them. But if you go to the UWV, you will have to demonstrate that you can only perform the activities if all 4 staff is on the payroll, will remain on the payroll. right. The consequence of the NOW ruling. We are heading towards the second NOA ruling, and recently the secretary who's responsible for the NOA said in the media that the fine, which is now applicable if employers have a reorganization during the NOA application, during the NOA period, is going to be removed from the second NOA regeling. So I will refrain from going into the consequence of the NOA on the business, on a reorganization, because I will highly suggest to wait after the 1st of June, because then the new NOA regeling will be applicable. And as it looks now, based on the information given by the secretary, which is responsible for the NOA, the fine for the penalty, if you are reorganizing during the NOA, is going to be removed from the second NOA ruling. So there is a system of a penalty system applicable in the NOA, this NOA ruling for this moment. If you are going to reorganize during the period which you applied for the NOA, but that will be removed in the second NOA ruling. So if your company is doubting about reorganizing, well, wait till after the 1st of June, because then this penalty system does not apply anymore. There's a response in the chat about the previous question. Okay, thanks, I understand. If there are any specific rules or guidance about how best to have these type of internal discussions so that we don't need to go to dismissal, involve you, WV, I would appreciate you sharing them. I realize it's a bit away from the dismissal topic, and so I'm happy to pick up outside the webinar if that's easier. Yes, thank my Fenry, that sounds good. Martijn and I will share our email address and phone number at the end of the presentation, and you can have a call with one of us after this webinar, and we'll discuss this with you, because it's indeed a bit specific for your organization, but we're more than happy to discuss this with you after the webinar. So give us a call or send us an email after the webinar. Now trying to, so wait with reorganizing with a reorganization till after the 1st of June. Okay, some last topics related to the substantiation of the business economical reasons. What is a business location? An employer can have multiple business locations, for instance, various shops, and a business location recognizes in society as independent unit, and there must be an internal independent management at those locations. Then it can be seen as a separate business location of the company. For the answer to the question whether an establishment or business location in society is recognizable as an independent entity, it's important whether the business location presents itself externally as an independent business location, and this is recognizable for third parties. Now, Martijn will discuss how this is important, why this is important for the principles of reflection, the afspiegelingsbeginsel, which applies in the selection of employees. So it's important to assess if there are various business locations within the company where the principles of reflection needs to be applied for it per business location. So what's the reference date? The reference date is the date at which the photo is taken of the org chart within the organization. And based on that photo of that date, it's decided which employees for which positions will be made redundant. Because at some point of time, the employer needs to be able to decide, okay, what is my org chart? What positions do I have? Who work in those positions? And if I'm going to make the redundancies, which positions will be affected and who will be dismissed? Normally, the reference date is the date at which you apply for start the application process at the UWV, but it's also possible to have another objective decisible date. For instance, the date at which you asked for advice at the Works Council. That may also be regarded as the reference date. My last question, and then I will give the floor back to Martijn. What are successive employment contracts? So the duration of the employment relationship with the employer is assessed on the basis of the employment contracts that the employee had and where there has not been a 6-month interval between those contracts. Employment contracts with successive employers will also need to be taken into account. The successive employer is the employer who must reasonably be considered to be the successor with regard to the work performed. It's not important whether there's a knowledge of the qualities or suitability of the employee. So that's important. It's considered to be the successor with regard to work performed. The chain of successive employment contracts is considered to be interrupted if there's a period of more than 3 months between the employment contracts, in case there's this interval within the contracts predates the 1st of July 2015. So after this period, there must be a 6-month gap between those contracts, and before 1st of July, the 3-month gap is also sufficient to stop the chain of employment contracts. So it's important to assess whether there have been successive employment contracts for the employee, and maybe also be at the previous employer of the employee to assess if that previous employee is considered to be a successive employer. One last. All right. I will give the floor back to Martijn now.
All right. Let's move on with the presentation to the next topic. Let's see. Yeah. Yes, first of all, a slight correction on the topic of when to establish his Works Council. Trippier asked a question on when to involve freelancers. This is in principle only applicable in case you would hire those through a temporary workers agreement, uitzendcontract. So perhaps a short call after the webinar would be good to see if in your situation you should include the freelancers. Selection of employees. Let me get my papers. So in the Netherlands, you cannot simply select your employees for dismissal the way you want, which is commonly the case in, for instance, the US. As a reorganizing employer, you're not entirely free to choose. For a long time, the rule was last in, first out. For each position, it was checked who had recently entered employment, and those employees were nominated for dismissal. This was changed more than 10 years ago, and then the reflection principle, the principle of reflection, afspiegelingsbeginsel, was introduced. From that moment on, layoffs had to be divided equally between age categories, and the last employee in each age category is fired first within the position. Now, how exactly does this principle of reflection work? First of all, you'd have to look at the company location and mutually interchangeable positions. In a reorganization, you do not simply look at the employee's position that is being made redundant. No, you should look at mutually interchangeable positions. So if you say you want to fire an employee and say, well, my employee is an admin worker, and we can do without 2 admin workers. You'd have to check if there's any other positions in the company that are mutually interchangeable with the admin worker. So this means that you have to see whether positions are equal or equivalent in terms of content, required knowledge, skills, and competences, and that the temporary or structural nature of the position, and that they are equivalent in terms of the remuneration level. So you don't simply look at the job title, but you look at other aspects as well. Right? Most of the times, job content and required knowledge are decisive. And then you bundle those positions, and that's the position where the dismissals take place. In principle, this means that you look at activities with a broad view. I think in most cases, the job description suffices as a point of departure on how to determine, well, which positions are mutually interchangeable. But if the job description is dated, missing, or if the practice is different, which is often the case, then you'd involve the way the job is performed in practice as well. In principle, you view this as the level of a business location, a part of a company that can be recognized as an independent unit and has an internal independent business operation. If you've determined in which category mutually interchangeable positions should fall, you'd first say goodbye to the flexible shell in that category. And by flexible shell, I mean on-call workers, employees with a definite contract that terminate within 26 weeks, temporary workers, and also people who have already reached the pensionable age. If the deduction of FTEs cannot be achieved by saying goodbye to those workers, then you would apply the principle of reflection among the employees with a definite contract. I think it's good to have an example, because this is all very theoretic, to see how this plays out in practice. So what you see here, you start at the top. There are 12 employees working in the category of interchangeable positions of, let's say, we call that seller. And now the first thing you do is you divide those employees in age groups. You see 5 age groups, and well, 3 in the first, 4 in the second, 0 in the third, 2 in the fourth, and 3 in the last. In total 12. Then you say, okay, it needs to be downsized by 4 employees. Then you distribute the employees among the age categories in percentages, right? So 3 out of 12 are in the first age category. You see that is of course 25% times 4 times the reduction you need to realize. It gives you 1, and you do the same for all the other categories. It gives you 1, 2, 3, 4 employees, of course. Based on the whole numbers before the decimal point, the distribution then is, and then you round it off. You see it gives you 3 employees, right? In this the table I'm now circling. In this example, 1 was calculated too little for dismissal. And then the age group with the highest value after the comma gives the employee to be nominated. Now that's this category, 45 to 54, that's 0.6666, it's the highest decimal point. So and the outcome would be that category provides you with the employee up for dismissal. And in the end, that's the outcome for employees spread over 4 out of 5 age categories. And then, of course, as a last effort, you need to nominate the employee with the shortest employment in the relevant age group for dismissal. Now, this is a very This is a very easy example. In practice, it can be much more complex, but luckily enough, there are tools that provide you with automated execution of this principle of reflection. As far as you have the right data, you put it into an Excel sheet, and in 9 out of 10 cases, it gives you the right outcome. So mutually interchangeable positions should be distinguished from suitable positions you see on the sheet. A suitable position is something different. A suitable position comes into play when you have to try to reposition an employee. Then you should look at what other suitable positions are there in an organization. And then you take a look at what the employee can do, cannot do. But with mutually interchangeable positions, you basically take a look at what the position entails. Something very different from what an employee can do, right? So this whole principle of reflection does not apply if there's a unique position that is not interchangeable with any other position at the company location. In that case, there's no need to apply this principle of reflection. Of course, as an employee, you must still have a valid reason for dismissal, and you have to make sufficient repositioning efforts. But in practice, it matters a lot if a position is unique, because as Mick already explained, you have quite a lot of room to substantiate the dismissal, as the UWV will not sit at the desk of the director. So you probably wonder, well, Martijn, this is quite unfair, this whole principle of reflection. Don't I have any leeway in selecting employees? Well, not much, but I'll go through the possible deviations right now. There is a deviation for a so-called indispensable employee. This is an employee that is, well, for instance, the guidelines of the UWV provide with an example for the successor of the business owner, right? The son or daughter that is nominated to be the next CEO. That could be an indispensable employee, but in practice, you hardly see that you can mark an employee as indispensable. You really have to substantiate why this is the case. Employee with disabilities. There are social programs initiated by the government, such as the WSW, participation laws, and they can, the employees that fall in a so-called activation scheme, they are excluded they can be excluded. See a chat popping up. I have to go to another meeting. All right, Anneke, all well. I hope you stay safe, and hope to see you next time in another webinar. The next deviation is if you have a CBA, a collective bargaining agreement, CAO in Dutch. A maximum of 10% of the number of employees who are eligible for dismissal can be disregarded in applying the reflection principle. But this should be included in the CBA. Then if you have the CBA that allows it, there are a couple of conditions that should still be met. Also, this whole principle of reflection can be set aside by a CBA, but then you'd also have to establish an impartial collective bargaining committee to decide upon dismissals. And this is only the case for a couple of very large companies in the Netherlands, such as the ABN AMRO Bank. In practice, I'm looking at the last topic of this bullet. It is possible to do so-called chair dance, which is my translation of stoelendans in Dutch. I'll explain what that means. Within a company, what you do is an existing position or positions are completely discontinued, so that all employees that work in that position, mutually exchangeable position, they become redundant, right? So you set aside a complete position, and you that is the first step you take. New jobs or jobs that are created are different. So what you do is you first say, okay, we're going to discontinue a certain position. We're going to create a new position holding new criteria, new basically new demands for the employee. And because the entire position is cancelled, you don't have to apply the principle of reflection as far as this new position that you've created deviates substantially from the old position, right? A successful application of the chair dance method requires that this old expired position and the new position that you create, of course, are not mutually interchangeable. So you should really look at that this differs from in terms of job content, required skill set, and also remuneration, I would advise you. So you have to really create a difference between the old and the new position. See, so further. Before 2015, the employer could then select based on quality which employees would be assigned to these new positions. And then you could say, well, the most suitable employee can be selected for the position. And the others that are not selected, as far as they can't be repositioned in another position, had to be dismissed. So this provided employers with a lot of freedom, right? You first basically remove a complete position from a company, you create a new position, you select the best employees for that position, and you dismiss the rest. Under the current law, it's still possible to apply this method, but with an additional condition that should be met. Because you'd have to apply the so-called inverse principle of reflection. And I would call it reverse mirroring. It means that the person who was last designated for dismissal is spared first. So eligible redundant employees, some of whose duties have been transferred to the new position, they take precedence over suitable redundant employees whose part of their old duties has not been transferred to the new position. This of course is also quite theoretical, so I will come up with an example of the chair dance. So you'd have, for instance, in a company, the position of project leader. 5 jobs in that position, completely cancelled. And you have the position of technical draftsman. 5 jobs in that position, 3 cancelled. You create a new position of project coordinator, and in that position, you have 3 jobs, 3 FTEs. So within a company, 3 out of 5 jobs are lost within the position of technical draftsman. Position of project manager with 5 jobs will be cancelled completely. All employees will be made redundant. Then you have this new position with 3 jobs. This new position is not interchangeable, not mutually interchangeable with the position of technical draftsman, nor with the position of project manager, project leader. However, in this new position of project coordinator, the activities of the cancelled project leader position will be continued, right? So in the position of this one, project coordinator, some tasks of the project leader will be continued. Well, 1 redundant technical draftsman and 4 out of the 5 project leaders turned out to be suitable for the new position of project coordinator. The question is then, who must you offer the new position of project coordinator? In this situation, the employer may not select the most suitable candidates, but it must first of all offer the vacancies to the suitable project leaders. Because in the new position of project coordinator, the activities of the expired position of project leader are partly continued, right? There's a continuation of a part of the tasks of the project leader position. Since there are more suitable project leaders than jobs, the employer must offer the new position to the 3 project leaders who, based on the principle of reflection, so calculated over the 4 suitable project leaders, have the highest reflection rights. So this offers you with a little bit leeway when you would when you think of, okay, I want to have more room to maneuver in determining which employees are made redundant, it's worthwhile to see, okay, what would be the outcome if I simply discontinue a couple of FTEs within a certain job, or if I discontinue a job altogether and create a new one. This could be, in practice, that gives you sometimes some room, and sometimes you have the outcome could be that you retain the employees that you need in your company. That is the topic of selection of employees. Of course, as a last reminder, if you do this chair desk method, you still have to objectively determine which employees are suitable in your view, and that is best done via an assessment or another method that is objective rather than your own subjective view on the employee's suitability. So we've now dealt with motivation, we've looked at selection of employees. Mick will now take over and talk a little bit about relocation.
All right, so relocation of or replacement of an employee. So file for submission to the UWV is not completed if we have not taken a close look at the possibilities to resign or reassign or to relocate the employee. It's important for all dismissal cases. You have, for almost all, in all grounds for dismissal, you need to have a look if you can reassign or replace, relocate the employee. So what's the law about the subject? The law stipulates that the reasonable ground for dismissal is present if there's a reasonable ground and reassignment, relocation within a reasonable period, whether or not with training in another suitable position is not possible or not reasonable. We'll focus on some key concepts, key aspects of the law. So when should an employer offer a suitable position? The employer will have to offer a suitable position if a vacancy is present in that suitable position, or a vacancy will arise within the reasonable period of time. What that reasonable period of time is, I will focus on the next question. Also temporary employment contracts and temporary contracts, insofar as ending within the reasonable period, must be terminated unless the work is of a temporary nature for a maximum of 26 weeks. Also, people entitled to state pension, AOW, and on-call workers, the oproepkrachten, will have to be terminated before the employee with a permanent contract may be made redundant. And also, they will need to be terminated, and the employee with a permanent contract must be reassigned to that position. What is a reasonable term for reassignment? The reasonable term for reassignment is the statutory notice period that applies to the employer to be able to terminate the employee's employment contract. So that depending on the duration of the employment of the employee, it's between 1 and 4 months. Within this period, a job must become vacant in a suitable position. Now, what is a suitable position? A suitable position is a position that matches the employee's education, experience, and capabilities. Salary does not matter according to a lower judge, but there's criticism on this verdict in the legal literature because it's the question of an offer. In this case, it was a salary cut of 700 or 800 euros a month on a 4,000 or 4,500 euro salary. So it's the question if that's still a reasonable offer for a suitable position if there's such a salary cut involved. Also, the possibility of training must be considered. if the employee can be made fit within a reasonable period of time using training, the position is also appropriate. So what does education or training mean? For the training or education obligation, an employer can in any case not be obliged to train an employee if there's no prospect of reassignment in a suitable position. However, the duration of training and the cost of the training are decisive for the question which training offer can be required of the employer. And also the financial position of the company is relevant for this assessment. So first of all, it must be established if there is a suitable position and if any training is needed for that suitable position. And depending on all circumstances, it must be determined if that training is suitable or is it's necessary for the company to offer the training for this specific employee to be able to fulfill the suitable position. If there's no suitable position available, there's also a training obligation for the employer, but that's more the general training obligation, not a specific training obligation if there's no a suitable position. We have no permanent contracts. Do we have more flexibility because of this or less? You have more flexibility because you don't need to have a look at we have no permanent contracts. No, so it's all for a definite period of time. Then yeah, you need to you have more or less flexibility. It's not determined per se, because if it's all definite for definite period of time, you will need to end those contracts because there's no work anymore. There's no assessment in that case because there are no permanent contracts. So permanent contracts have a better position, but if there are no permanent contracts, the rest is all the same, and you need just to end the definite period contracts at the end of the contract, or before that if it's better to start a UWV process and ask for permission to terminate those permanent definite contracts. So yeah, is there more flexibility? Yeah, it's not per se more flexibility. There's just no comparison with permanent contracts because there are no permanent contracts involved. Do I have to offer a vacancy for a position? It's up to the employer to determine which employee is most suitable for filling a vacancy. The employer will have to be able to justify his choice. This can be done, for example, by applying objective criteria for the job, or for example, by taking a suitability or capacity test. However, please bear in mind that this is only possible if you are not in the situation as Martijn just discussed, in which I thought he called it the reversed chair dance. But if that's not applicable, then you have as a company some room to decide which employee is most suitable for the position, but not in the case of the reversed chair dance, as Martijn just explained. What if you're part of a group? If the company is part of a group, jobs in the other companies of the group will also be involved in assessing whether a suitable position is available. Our Supreme Court, the Dutch Supreme Court, made it clear that this concerns a best efforts obligation for the employer to reassign an employee. It's important that the employer has made all reasonable efforts to relocate the employee. It's insufficient to point to vacancies on the intranet. An employer will have to enter into a dialogue with the employee to hear about the employee's wishes and, for example, to look for other options within the group together. It's important to stress, however, that the employer may not have control over the hiring policy of another part of the group. However, there's an obligation to play an active role by approaching the other company on behalf of the employee to inquire about interest in a possible suitable position at that company. So you need to HR, for instance, needs to play an active role to approach the other company and inform them that you have an employee for a vacancy over there. You have also need to make sure if the employee is willing to move abroad, if there's a suitable position available abroad. Case law indicates that employees regularly appeal successfully to breaches of the reassignment obligation. This obligation applies for other grounds of dismissal, and therefore it's regularly reflected in case law. So please record the reassignment efforts on paper. All conversations, all dialogues you have with the employee about reassignment, have them in writing, because it's necessary to show the UWV or judge in a later stadium that you have fulfilled the best efforts obligation in this case. And what if a position recurs a few months later? If the employee's job recurs a few months after the cancellation, so after the UWV process and after terminating the contract, there's an obligation to offer the job to the employee who's been made redundant. So it's important, it's only after you have terminated the contract after the UWV procedure. If there's a settlement agreement involved, this is not an obligation. But after UWV procedure, this is an obligation. This is called the so-called re-employment condition that is linked to the permission to terminate the employer contract by the UWV. This obligation means that if within 26 weeks after termination, a new position occurs and the performance activities in the job are the same activities as the employee performed, then this new position should be offered to the dismissed employee. For example, it doesn't have to need to have the same job titles. It's assessed if the activities of the position are the same or are similar to the position the dismissed employee fulfilled. And please be aware that LinkedIn has proven to be an excellent resource for dismissed employees to substantiate their case if they see that the new employee is performing almost the same activities as the former employee did. In case there's a suitable position that arises after the termination of the employment, so after giving notice, but before the end date of the employment contract. So for instance, notice is given today, the 15th, and the end date is the 1st of August. And between now and the 1st of August, a suitable position occurs. It does not lead to an obligation to offer the suitable position. At the moment of giving notice, that's the moment you have to check if there are suitable positions or if it's reasonable to suspect that there are going to be reasonable or suitable positions available. But if another employee terminates their contract, gives notice to the company that's leaving the company, then you do not have to offer that suitable position if it becomes available after giving notice to the employee. So that's about the reassignment. We have a couple of last topics. I will focus on the termination payment and other payments which might be an employee be entitled to. So is an employee always entitled to the transition payment? Yes, after terminating the contract by giving notice, after having the permission, given the permission by the UWV, the employee is entitled to the transition payment. In a settlement agreement, it's not by law that the employee is entitled to the transition payment, but also it will also always negotiate at least a transition payment, because any employee, or at least the legal advisor of the employee, knows that after a UWV procedure, the employer has to pay the transition payment. So the employee is entitled to this transition payment. Is there a right to transition payment for part-time dismissal? Yes, it is. It's the Supreme Court established that at a part-time dismissal, if it's for more than 20% of the working time of the employee, then there's a pro rata transition payment. The employee is entitled to the pro rata transition compensation, transition payment. And there has been a case law about if you are resigned to a lower position with a lower salary, is there also a transition payment? Is there also a case for a transition payment for the employee? And there the Supreme Court has ruled that it's not the situation. So if there's no case of dismissal, the Supreme Court argues. So in case of part-time dismissal, there of more than 20%, the employee is entitled to a pro rata transition payment. But if the employee is reassigned to a lower position with a lower salary, then there's no transition payment for the employee. It's not entitled by case law. Last, can I discount any employability costs from the transition payment? Yes, it's possible under specific circumstances. If you make employability cost during the employment of the employee, for instance, for a specific training, it is possible to discount it from a future transition payment if it's documented correctly. So please be aware of this possibility that employability cost may be deducted from a future transitional payment if documented correctly. So please bear that in mind for the future as a takeaway for now, because I will hand over to Martijn and I will leave you guys for it because Martijn will close this meeting after the last topics. Thank you for attending this webinar and see you next time.
Couple of last topics on cancellation bans. Cancellation bans are so-called opzegverboden in Dutch, so you cannot dismiss an employee in a specific situation. Most importantly, illness, so disability for work is a cancellation ban. During the time this applies, so during the time the employee is disabled for work, this dismissal permit will be refused unless it can be reasonably expected that the prohibition for dismissal, so the disability, no longer applies ultimately after 4 weeks after the decision of the UWV has been issued. So this is far-stretching. This means that the legislator says, I think disabled employees should be protected even in case of a reorganization. And this is also the reason that you commonly submit this A form to block a sickness notification. It does not apply to company closure or party company closure. The next cancellation ban is the membership of the Works Council, prohibition of a termination of a member or a candidate member for the Works Council. It applies unless the employee has worked in this position for at least 26 weeks. And this rule has been introduced to prevent the employer from placing a Works Council member in another position and then dismissing this individual. Pregnancy and maternity. The prohibition of termination during pregnancy does not apply if there is a complete termination of the company and if the company's activities are partly terminated. In the latter situation, the additional condition is that the employee must have been working at the job for at least 26 weeks. So the same additional condition as with the Works Council members. During the period of maternity leave, the prohibition of termination is absolute. The employee's employment contract cannot be terminated, also not during in case of the company termination. And dismissal of a worker during maternity leave is not possible. But then again, you would obtain benefits from the UWV during the period that maternity leave applies, and after this leave, it would be possible to terminate the contract. So is this dismissal simply impossible in case one of those cancellation bans applies? No, it's not impossible, but you could consider to either wait or until the ban doesn't apply anymore, or you try to seek a settlement agreement with the employee, taking into account the time when it takes for the prohibition to terminate doesn't apply any longer. This can be the case, for instance, with sickness. If you have a company doctor involved who says, well, I expect this employee to be better again in 2 months, then you could consider to offer a package with an additional 2 months time added to the dismissal period, to the notification period. Then, alternative dismissal route. This is the something we often see in practice. Can a business dismissal or a business reorganization be an alternative in case it's hard to fire an employee for personal reasons, or in case it would be too expensive? Think of the situation in which you as an employer are confronted with a dysfunctional employee and are not prepared to implement an improvement plan, not prepared or not willing, or too complex. The employment relationship may also be a little bit disturbed. A route could be to offer that employee an improvement plan as well as a settlement agreement, what commonly is done. But that may still be costly. We would have a discussion about whether the employee is underperforming, the duration of the improvement plan in relation to the offered compensation. And sometimes it is simply possible to cut his or her position instead of going through this whole ordeal of an improvement plan. Of course, this only works for unique positions where you can argue that it is in the best interest of the company that the work belonging to the position is organized in a different way. Think of automating work, distributing work among colleagues. And as Mick already indicated, the UWV tests marginally. So it doesn't say, well, doesn't test, would I have done the same if I were in the shoes of the director? And when you offer the employee an incentive in a settlement agreement, so you first submit this A form, right? You have to sit down with the employee, make him an offer. You include an incentive as in comparison with the outcome of the UWV proceedings. Many employees will agree to the settlement agreement because they have to outweigh the chance that their employment will be terminated by the UWV proceedings, and what they will then get in terms of final settlement, transitional compensation, in comparison with the incentivized offer that they are getting. So this could be, well, keep in mind this option in case you have a difficult dismissal at hand. Last topic, the bankruptcy. I'll not go into this topic in very much detail, but know that an application for bankruptcy in very serious matters, in case you cannot pay the bills anymore, is possible. It can be your own application, it can be application of creditors. What generally happens is that a trustee will be appointed who will dismiss all personnel with a notice period of maximum of 6 weeks, and the MPs would still need to be working. It also, so what benefits would you have to pay, or would the employees get? In the case of bankruptcy, as an employer, you don't have to pay any benefits because, well, there will be a situation of bankruptcy. The UWV takes over a number of payments. You see them listed. Wages for a maximum of 13 weeks before the moment of the dismissal. So already, if you've already stopped paying salary for a moment, for a while, that's compensated for by the UWV. Wages during the notice period for a maximum of 6 weeks. And then holiday pay, vacation days, and pension payments, a maximum of 12 months prior to the date of the dismissal. And this is maximized to 150% of the maximum daily wage. The maximum daily wage is currently about 4,600 euros gross. So the higher incomes are not taken into account fully. Of course, bankruptcy has serious implications for the company as a whole, for its reputation, for its directors. So it's something that you shouldn't simply choose to avoid having to pay the transitional compensation, but you should be advised on all consequences before considering this. That was it for us. A global overview on economic dismissals under Dutch law. Hope you've enjoyed it, found it useful. We are available for your questions. You see, we will send this presentation along with the recording this afternoon. We hope to see you next time with another webinar, and hopefully also in real life at some date. Thanks very much. Goodbye.